Act, PL 1975, Chapter 231, adequate notice of this regular meeting of the Board of Adjustment of the Township of Franklin has been provided. Board members, applicant, professionals, and members of the public, please speak directly into microphones so that our recording secretary can properly process minutes. Applicants and professionals, please fill out the sheet on the table when you've completed your testimony. Thank you. First item, roll call.
Anthony Caldwell, I don't see. Laura Grauman.
Here.
Bruce McCracken.
Here.
Alan Rich.
Here.
Robert Shepard. Gary Rosenthal.
Here.
Joel Reese is going to be out until, I think, April or May, or March or April, just so you know. He's that way. Cheryl Bethia.
Here.
And Chairman Thomas.
Here. Minutes of the regular meeting, November 7th, 2019.
Move the minutes?
Need a second?
Second.
Okay.
Bruce McCracken.
Yes.
Alan Rich.
Yes.
Cheryl Bethia.
Yes.
And Chairman Thomas.
Yes. Resolutions. Dawatul Islama of Somerset, ZBA 19-00004.
Second.
Laura Grauman. Bruce McCracken.
Yes.
Alan Rich.
Yes.
Gary Rosenthal.
Yes.
And Chairman Thomas.
Yes. Amy Wilmot, ZBA 19-00021.
Second.
Laura Grauman.
Yes.
Bruce McCracken.
Yes.
Alan Rich.
Yes.
Gary Rosenthal.
Yes.
And Chairman Thomas.
Yes. Shatkin Patel, ZBA 19-00025.
Second.
Laura Grauman. Bruce McCracken.
Yes.
Alan Rich.
Yes.
Gary Rosenthal.
Yes.
And Chairman Thomas.
Yes. Gina Ulrich, ZBA 19-00029.
Move it.
Second.
I need a second. Oh, Robert Thomas, okay. All right, Bruce McCracken.
Yes.
Gary Rosenthal.
Yes.
Cheryl Bethia.
Yes.
And Chairman Thomas.
Yes. Noreen Dot and Karen Sipersad, CBA 19-00026.
Move it. I don't think,
I didn't get that one either.
Follow the
copy of the rest. Get a copy?
Oh, supper son?
I didn't. Last one I got was Gina Ulrich.
But it's the last one, but,
I know,
okay.
it's the last one, but I didn't get it.
Okay, well, you can't vote anyway, sorry, you weren't
Well,
here.
that makes it simple.
I'll move it.
Okay.
Okay, Bruce, you're moving it, and who's second?
I'll second it.
Who's that? Oh, Alan. Okay. Bruce McCracken,
Yes.
Alan Rich,
Yes.
Cheryl Bethia,
Yes.
and Chairman Thomas.
Yes. There are no discussion items. Under hearings, the trust under Article 6, Sigmund Summer and Levin Properties, ZBA 19-00015, applicants requesting the site plan approval for 50 townhouses provided in 9 separate buildings with 179 parking places at 31 Cedar Grove Lane, Somerset, Block 468.09, Lot 34 in the R40 zone. The development previously received a use variance approval carried to January 16th, 2020 with no further notification. Nestor and Victor Marin, ZBA 19-00027. Applicant seeks C variances in association with a 2-family home with 1 5-bedroom unit on the first and second floors and a 2-bedroom unit in the basement at 204 Franklin Boulevard, Somerset. Block 275, Lot 1.01 in the R7 zone, carried from October 17th without further notification.
Good evening, Mr. Chairman, members of the board. Peter Lanford, appearing on behalf of the applicant. This is an application to allow a two-family house in the R7 zone where single-family and two-family houses are permitted uses. The reason we are before the board is that in order to have a two-family house, we are required under the current ordinance to have a lot area of 15,000 square feet, and the lot in question is 13,309 square feet. So we have a lot area deficiency. We also have a frontage variance, which is an existing condition for the frontage on Highland Avenue. This property is a corner property. One of the frontages is 150 feet, which meets the zone requirements, and the other is 90.48 feet, and again, that's an existing condition. I have two witnesses this evening, Mr. Marin, who is the owner of the property, and also Mr. Dumas, the architect, who is also a licensed professional planner. Mr. Marin?
Good evening. Hello, my name is Nestor Marin. I live at. I got it. Sorry.
Stand up.
Sorry about that.
Speak right into the microphone. Do you swear the testimony you're about to give should be the truth?
I do.
Your name and address, please.
Nestor Marin, 198 Franklin Boulevard.
Okay, Mr. Marin, you are the applicant in this matter.
That is correct.
You own the property
Yes, I do.
by yourself or with someone else?
With my dad.
Okay. And when did the property first come into your family? When did your family first start owning the property?
I believe my dad first purchased it in 2004.
Okay, hold the microphone. please.
2004.
Okay. And when your dad purchased the property in 2004, was it a single-family house or a two-family house?
Single family home.
Okay. After he purchased the house in 2004, did he make any modifications to the house?
Yes, he did in 2006 when I moved in with him.
Okay, you moved in with him, and what modifications did he make?
He adjusted the basement so they can live downstairs, so we can move upstairs on the first floor.
So your dad then moved downstairs and you moved upstairs?
Correct.
However, when you made the modifications to the house or when he made the modifications to the house in 2006, did you obtain or did he obtain any permits to convert the basement into habitable living space?
I believe he did not.
Okay. And so at some point in time, it was discovered that this is a two-family house that has never received approval to be a two-family house.
Correct.
Since 2006, has it been used and functioning as a two-family house?
Yes, he has.
Okay. And at the present time, in the basement, how many rooms are there?
2 bedrooms.
There are 2 bedrooms. What other rooms are there in the basement?
Just the living room and the kitchen.
Okay. And at the present time, does your dad still live there?
No, he does not.
Okay. Who lives in the basement?
I do, with my wife.
So you and your wife live in the basement?
Correct.
And as the application states, on the first level, there is a 5-bedroom apartment. Is that correct?
That is correct.
And who resides there?
My in-laws.
Okay. And that has always been a 5-bedroom apartment. That has never changed?
No modifications upstairs, correct.
Okay. So the only modifications that were made were to the basement to create the 2-bedroom apartment?
That is correct.
Okay. Thank you. I have no further questions.
Anything from the board?
So the upstairs has a kitchen and living room as well?
Yes.
Yes, correct.
And the basement has no restroom in it, no bathroom?
There was an existing one by the laundry area.
Is there a laundry area upstairs as well, or does the laundry area and utilities for the whole house?
The utilities is next to the laundry area downstairs in the basement.
It's for the whole house?
Correct.
Upstairs and downstairs?
Yes,
Yeah, there's a kitchen downstairs too, I guess.
yes, correct.
Just so we make it clear, the apartment downstairs has a bathroom and is a completely functional and independent apartment from what's upstairs.
Yes, with a separate entrance and everything.
Separate entrance and everything else.
Now, does the facility meet all the building code regulations for two-family?
I can't answer that. They're going to have to get necessary permits from the construction department.
So there is that safeguard, if that's what you want to put it
Well,
at. It'll have to meet code.
Oh, it definitely have to meet code. I mean, if the board decides to grant the variance,
That would be,
that doesn't, eliminate the need to do whatever they need to do to make that space compliant with code, with respect to, egress windows and et cetera. I don't know, I have no idea if it's code compliant.
Yeah, we can address that, and we do have to make an application for a building permit, and they will have to inspect what work was already done, and actually, we do have to do some things to make it code compliant, and the architect will explain that.
And Mr. Lanford, there were some comments in the TRC report about parking, about the expansion of the driveway, the parking within the right-of-way, et cetera. Who's going to, is this?
I can deal with that issue. Basically, well, I'll deal with part of it. At some point in time, you widen also the driveway to handle the cars for the house. Is that correct?
My dad did, correct.
Your dad did. You're blaming everything on him. And obviously, he did not obtain a permit for that either.
Correct.
Okay. And Mr. Healy indicates that some of the areas that are used for parking may be in the right-of-way, and obviously you're not allowed to park in the township right-of-way, so if we have to modify the parking to get all of the parking out of the right-of-way, we can do that, and you will obtain the appropriate permits to do that. Is that correct?
That is correct.
They're going to be sufficient to accommodate that?
Mr. Dumas has a sketch to show that we can, with some modifications, actually can accommodate 6 cars on the property and still meet the impervious coverage requirements.
There's parking across the street, I noticed.
Yes, there is actually the next street over on the next corner. There's space for more parking. We have a total of 5 vehicles, which fit now as it is. The vehicle that they speak of that was on the right of way is no longer in use. That's when my dad was still here, which he retired last year, and he's no longer using that vehicle. So right now, we only have 5 vehicles which fit properly in the driveway as it is.
any other questions? We'll wait and open to the public once.
Okay. Mr. Dumas?
Could you raise your right hand? Do you swear the testimony you're about to give should be the truth?
Yes, I do.
Your name and address, please?
Sure, it's Jimmy Dumas, D like David, U-M-A-S, and it's Jimmy, not James, 24 Braxton Drive, Belmead, New Jersey.
Thank you.
And you can be seated, Mr. Dumas. Mr. Dumas, what is your occupation?
I am a registered architect and a professional planner.
Okay, and have you appeared before this board on prior occasions?
Yes, I have many times.
And your qualifications have been accepted by this board prior?
Yes, they have.
And they haven't changed? You're still both a licensed planner and a licensed architect?
Right, those are both
Okay,
active.
That's fine.
Sure, thank you.
Okay. Mr. Dumas, you assisted Mr. Marin in preparing the plans that are subject to this application.
That is correct.
Okay, can you briefly describe the house as it currently exists, and then we will talk about what changes we will be making?
Sure. So when I was hired earlier this year, I was able to measure the existing house that has currently, as stated before, a 5-bedroom apartment on the first and second level, and then a 2-bedroom apartment on the lower level. So there's a total of 3 levels. The top 2 levels is 1 apartment. The lowest level is another apartment.
Okay. And how is access gained to the upper level apartment?
The access is gained off of Highland Avenue. There's an entrance that you are able to go through that door up a few stairs, and then you can get to the main level and then go to the stairs to get to the second floor.
And how do you access the basement apartment?
The basement apartment, you would have to go around to the other side and actually go down a few steps to get into the basement apartment. So there is a separate entrance for that.
Okay. And you examined the existing conditions in the basement apartment, and as a result of examining those conditions, do they meet all the current code requirements to qualify that as an apartment?
So what I observed was, as far as dimensions, that it did. So the bedrooms were of adequate size that met code. However, some of the windows were undersized for proper egress, and in the drawings that are part of your package, and I show the egress that's necessary in order to to exit the windows if needed in an emergency.
So the only physical change, if you're going to be looking at the house, if the board were to grant the variance outside tonight, would be that the windows to the basement would change,
That is correct.
and they would meet code requirements.
That is correct.
Okay, and you heard my statement prior with respect to whatever improvements Mr. Maron's father may have made in order for the apartment to be a legal two-family, it would have to be inspected by the building department, and if other things aren't to code, they would have to be brought up to code.
That is correct. In addition, they would have to fill out permit application cards for all of the trades. Since the bathroom was existing, it would be electrical and building and fire.
Now, in your capacity as a professional planner, can you describe the neighborhood and the history of the zoning of this property?
Sure, I can. So the history of the neighborhood, from what I could tell over, I would say maybe the last 40 to 50 years, was essentially mainly single-family and some two-family properties. Most of them were around 9 to 10,000 square feet. This one's unusual in the fact that it's over 13,000 square feet. But for the most part, there's single-family and two-family houses in the immediate neighborhood.
Okay. And with respect to the zoning, was the zone requirement for this area for a two-family house always 15,000 square feet?
It appears that back in 2006, the master plan required two-family buildings to have only 10,000 square feet. So it looks like it was changed a little bit more than a dozen years ago.
So if Mr. Maron's father actually went in and got permits in 2004 or 5 and 6 when he made these changes, it would have been a permitted use and would not have required a variance. But since the zoning changed, he now requires the variance because the lot area does not meet the lot area requirements. Is that correct?
That is correct.
Dealing with the driveway and the parking of vehicles, you were to the site and you saw how that parking it currently exists. And is that shown on your drawing?
It is shown on, actually I have a few photos, and so I'm going to scroll through it quickly here. Let's see. Let's see. I think that's probably the best image. So you can see this is the house in question here, and currently the parking is kind of a fan-shaped parking arrangement.
Okay, before you go further, that is from Google Maps, and that's an aerial photograph?
That is correct, from 2019.
And I guess we need to mark that as A1, because we did not submit that as, did you submit that as part of your application?
No, I did not.
Okay, so we'll mark that as A1. Okay, and you indicated that the parking lot, or driveway and parking area is basically on which of the two streets?
So the parking is on the Highland Avenue side, and as you can see, the one car that's closest to the curb, I think Mr. Maron had already testified that potentially that was his father's car, and it is in the right-of-way, so we're aware that that's not permitted.
Okay, and do you have a solution on how to park 6 cars on that property without any of them being in the right-of-way?
Yes, which will be the next exhibit here.
So can we mark that as A2?
Could you describe what A2 is?
Sure. A2 is essentially the existing survey with a superimposed sketch showing a 6-car parking area.
And that sketch was drawn by you?
Correct, that is.
Okay. And can you indicate how the driveway and the parking would work?
Well, so what I did was use the existing curb cut and essentially put the 3 parking spaces on one side, 9 by 18, and then 3 on the other side. So the idea would be to not enlarge the curb cut, possibly, if necessary, reduce it, if that's not too much of a hassle, and then create a driveway in front of the house. Obviously, one of the concerns would be impervious coverage, but we are roughly, I would say we're roughly about almost 1,500 square feet under the impervious coverage limit, so we're well beyond, we would be well under the maximum impervious coverage requirement.
Okay, thank you. Now, in your capacity as a licensed professional planner, do you have an opinion as to whether if the board would grant the variance for the undersized lot, which is the only variance that is being created by the application? The other variance, the lot frontage, is an existing condition, is that correct?
That's correct.
Okay. Do you have an opinion as to whether the grant of the variance by this board would in any way impair or detrimentally affect the zone scheme or zone plan?
I do not. I think that granting the variance would be in alignment with the current zoning.
And why do you say that?
I say that because in reviewing the technical report, there was a question of whether or not this could be seen as a C1 or C2 variance. The C1 variance being a hardship variance, C2 being the benefit, the zoning benefits. That's what we call the C2 variance. So I didn't want to see it as a C1 because basically a hardship variance is one that could not be resolved based on a situation caused by the homeowner. So we're looking at this as a C2 variance. And then there are a few stipulations in order to grant a C2 variance, and mainly it's the benefits versus the detriments. And in reading the municipal land use law, was able to come to a conclusion that a C2 variance could be granted.
Why do you conclude that? What are the variance?
Well, the benefits, actually, in order to satisfy, you have to look at 5 different criteria for the C2 variance relief. And one of them is that the variance must relate to a single specific piece of property. And earlier I testified that this property is a little bit unusual in the fact that it's 13,000 plus square feet, and most of the lots in that area are around 10,000 or even 9,000 square feet. So that's one of the criteria.
Okay. Now, you also heard Mr. Marin testify that this house has functioned, in essence, as a two-family house for at least the last 13 years. Is that correct?
That is correct.
And other than the issue of the parking in the right-of-way, which can be remedied, in your examination of the property and visiting the property, is there any reason why it can't continue to function as a two-family and not have any detrimental impact because the lot is slightly undersized?
Right, that's correct. There is no reason for it not to operate the way that it currently is.
Thank you. I have no further questions.
Any questions from the board?
I assume, although since there really is very little change, that there's been no issue with the neighbors?
I can have Mr. Marin answer that question.
No, we have not. We have not been told, or we don't have any issues with our neighbors because of this.
Any other questions?
So it's the redesign of the parking, right now it's not lined up. I mean, it's not laid out. And people park the way they park. And now are you gonna align it so that, or do you expand the parking, or?
The exhibit that's shown by, actually, the still on the board would really create, and I don't think we're going to line, this is a residential property. I don't think you want it striped like it would be a.
Well, it is there.
Yeah, just to show that we can fit the cars. But basically, we would create a driveway with the ability to park 3 cars on one side and 3 cars on the other. As a practical matter, as he indicates, there's only 5 cars that are there most of the time. But that's what we would do, and if the board would approve it, we would have to get the appropriate permits to also modify the driveway.
So the main change is just, you're going to put curb?
There is a curb cut already, but we would, again, depending on what the engineering department wants, we would make it code compliant, and we would have all the parking out of the right-of-way.
With regard to,
My concern is just the access in and out with the 6 cars, because now there's a lot of room for them to pull in and out.
What I was responding, and Mr. Lanford's correct, that there would not be any striping. It is a driveway, but that there would be adequate space for a car to always leave facing out. so there's no backing out into the street. So that's the key. And since it's not technically like a parking lot for retail or so forth, we may be able to squeeze it just a little bit, but again, it would have to be approved by the engineering department in order, before that work could be done.
Let me understand what you said. Are you suggesting that in order to park in those spaces, someone would have to back in so they could drive out, going forward, or they, you understand what I'm
Right, I
saying?
understand what you're saying. So I would say the way that it's designed, the way I want to design it, is that there would be no need to back out. As far as if they back out currently, I'm not aware that you do or that you don't. So it would be it's best not to back out on a street like that. Because
No, okay.
maybe we're,
I think we're talking at cross purposes.
I think what he's saying is the way it's designed, someone who's parked in that driveway can adequately turn around on the site so that they will be driving
Okay.
out forward. Is that where you're?
Yeah, I was thinking, for example, if you park at a supermarket parking lot, you can either back into or
Yeah.
drive directly in, but what you're talking about is something entirely different.
Yeah, what we're talking about is the ability for somebody, if they pull into one of those parking spaces, can then back out and actually drive out onto Highland Avenue without having to back out onto the street.
I think if you look on page 3 of the TRC report, there's a photo of the existing driveway. And I think the way to think of it is if you see the curb cut and there's parking to the right of the driveway, and what they're essentially proposing to do is to expand the driveway to the left where there's that grass.
Right, okay.
So you'd have basically 3 on the one side of the curb cut and 3 on the other. And it wouldn't be striped because it's a residential driveway, but the exhibit is showing that there's room enough to have 3 cars on each side in that driveway.
Okay, I don't have a problem with that. I just was trying to understand what he was saying in terms of the.
Yeah, I felt the same. I was just concerned that with the 5 cars already parked in there, now to get out, there would still be sufficient room for them to turn around and get out without having to back out.
That's correct.
And not be forced to park in a back-end way.
No, they can back out and then head out onto Highland Straight.
so ultimately, we're improving the parking.
Do you have paper copies of C1 and C2 with you?
I have.
Or A1 and A2, I'm sorry.
I have paper copies of A2, which we can mark into evidence. I have that. I do not have a copy of the aerial, but we can
So
provide.
you can provide that.
Yes.
Okay, one concern I have is, I think all of this can function, and I think it will in the present situation, because you have an owner-occupied apartment. I'm just wondering if it will work as well if it ever becomes a situation where there's absentee ownership and tenants. You have a potential for a fair number of people in the 3-bedroom apartment, and it seems that's the parking situation might need some sort of minimum supervision or oversight.
Well, the parking would meet the RSIS requirements, so we would have enough parking for the number of bedrooms that are in the 2 apartments. Obviously, if Mr. Marin rented an apartment out to somebody other than a family member, in the lease, they would probably have to designate, how many cars they would have, and that would be, again, you're right, it's a management issue that the owner would have to deal with. But I think the one thing you as a board don't want to do is put restraints on, because you may have somebody who rents the downstairs apartment who only has 1 car, and I don't think you want to say, well, you have to have 2 parking spaces for the downstairs apartment if there's only 1 car. I think those are all management issues that whoever owns the property will ensure that, people park so that they peacefully coexist, because it may be that the downstairs apartment only needs 1 parking space and there will be 5 spaces for upstairs. So, and which is fairly typical. I do a lot of work in New Brunswick, and we have numerous apartments with college students, and the landlord has to manage who can park when, where, why, and how, and it most of the time works.
Any other comments?
I've got a couple questions. You kind of skipped over the basement. What needs to be done in the basement to make that compliant?
Sure, actually, I have the architectural drawings here as well. Let's see, if we go to A01.
Before you go
Sure.
into, those drawings are part of the plan set that were submitted in conjunction with this application, and they are marked, and the board's plan set is A01?
That is correct.
Okay, now you can talk.
All right, so to answer your question, there are 5 windows in the basement. 1, 2, 3, 4, 5 that do not have adequate area for egress. And in order to do that, that's what this detail is above, is that we have to make the window large enough, but since it's below ground, we have to excavate and create, and this is a prefabricated window well that would be needed in order to provide that, and it's recognized as an adequate way for providing egress. So that's with the basement, and that's for living area, specifically the 2 bedrooms. The 2 bedrooms, and then also the family room and the kitchen.
Okay. My second question is going to go along with the chairman. This is, we have people living in the upstairs, people living on the first floor, and people living in the basement. So it's all okay if it's family, but it gets sold. Now, the buyer probably thinks, well, I got a 3-family house here now.
Oh, it's a 2-family because the
I
upstairs
know,
is.
but I'm saying
No,
they
but
can.
the upstairs is like a 2-story apartment. They're not separate apartments on the second and
They're
third
not.
floor?
No,
It's the above ground is all one
Yes.
family.
it's a single-family
Okay.
rental apartment that has 5 bedrooms. It
Okay.
has a kitchen, living room, bathroom, typical apartment.
Any other questions?
Public?
That concludes my testimony.
Okay, then before we go any further, we'll open to the public if there's anyone who has any questions concerning any of the testimony you've heard about this application, or if you want to make a statement concerning the application. The mic is open. Looks like we have no takers, so
Just very briefly, Mr. Chairman, again, this is a zone in which two-family homes are permitted uses, so we are not seeking to introduce into a zone that only has single-family homes a 2-family dwelling. The reason we are here is because of the lot area, and we've, I think, clearly demonstrated that this lot, even though it is undersized for a 2-family house, will function adequately. We can provide all of the parking. The house itself doesn't change other than the improvements that we need to make for ingress and egress, but the 4 walls of the house as a result of this application don't get bigger. It doesn't get wider. The house will remain the same, and it has existed as a 2-family house for the last 13 years without a problem, and the only thing that will happen is this board would then ratify that it is a 2-family, and then that would compel my client to actually make it code compliant, which is a benefit to everyone, and I would respectfully request that the board grant the variance for the insufficient lot area and the existing lot frontage variance.
Mr. Chairman, if the board is inclined to approve it, I just want to bring up a few things. So right now, the apartment exists, so, and there are a few things that they need to rectify to basically make it right. They obviously need to get the zoning permit for the driveway to widen it as they've indicated, and then they need to actually construct it. They need to remove the pavers or the gravel from the right-of-way and return it to lawn. And they need to submit the building permit for the improvements to the windows, et cetera, and they also need to register it as a rental unit with the clerk's office. So those are things they need to do to make it right. What I would suggest is if the board is inclined to approve it, that they put some time limits on that to compel the applicant to do it within a reasonable time frame.
What do you think would be a reasonable time?
I'd put it on, I'll ask the applicant first to make a suggestion, and then I think the board can react to that.
I think we'd like to start doing everything right away, and I think, I mean, there's two separate permits. We got to go through the building department, and our plans are basically ready to go there. We probably have to do a little bit of engineering work to get a permit for the driveway. I'm not sure yet, so I would think that we would have to have all of our permits submitted within 90 days, I think would be a reasonable timeframe to get it done.
Submitted within 90 days?
Well, the building permit, we could probably submit within 30, but it may take us a little longer to.
I don't know if the driveway would really need engineering, because, I mean, the only reason you would need engineering is if you're increasing the impervious by 1,000 square feet.
and we're
I
not.
don't think you are. So
Okay.
it's literally drawing up the plan, submitting A2 as a zoning permit, and building it.
If we're on the same page, then we'll submit the permit. If something obviously is needed after that, we'll do it. But if you want to do it within 30 days of the resolution of approval, that's fine. I mean,
You can submit all of those within 30 days?
Yeah, because 30 days of the resolution, we have a little bit of cleanup work, but the resolution will probably be adopted within a month, and we could do it within 30 days of that.
I think that's reasonable, certainly.
Any other questions, comments, or motion?
Subject to all of the conditions that Mark described, I would move.
Second.
Okay,
Laura Grauman,
Yes?
Bruce McCracken.
Yes.
Alan Rich,
Yes.
Gary Rosenthal,
Yes.
Cheryl Bethia,
Yes.
and Robert Thomas.
Thank you.
okay. Damon Barber and Alina Newton, ZBA 19-00033, applicants requesting a C variance from a 20% impervious surface limitation at 1743 Amwell Road, Somerset, block 417.01, lot 6, in R40 zone.
Good evening, Mr. Chairman, members of the board. Peter Lanford appearing on behalf of the applicant. This is an application which is a little bit different than many of the applications I've presented before this board. We are here to seek an impervious coverage variance for the driveway that is on the subject property. I will be calling two witnesses, Mr. Barber, who is the owner of the property, and Mr. Fisk, who is a licensed surveyor. Mr. Barber, I'll ask him some questions to take you through the history, which is a little bit unique regarding what happened here. And then we actually have already, or he has already paved the driveway, and actually as a result of this application, should the board approve it, we are actually going to be eliminating some of the pavement that is already there. With that background, I will have Mr. Barber sworn in.
Would you raise your right hand? Do you swear that the testimony you're about to give should be the truth?
Yes, I do.
Your name and address, please?
Amon Barber, 1743 Anwell Road, Somerset, New Jersey.
Thank you.
Mr. Barber, you are the owner of the property at 1743 Amwell Road?
Yes, sir.
Okay, and with whom do you reside at the property?
Myself, Elena Newton, which is my wife, well, Elena Barber.
All right,
Okay,
talk
here?
louder.
Okay, Elena Barber, my wife, my daughter, and my mom.
Okay, so there's four of you that reside on the property.
Yes.
When did you buy the property?
I bought it in August 2017.
Okay, and this is a single-family house, correct?
Yes.
And it's actually right around the corner next to the Board of Education property and across from the church?
Yes,
And
sir.
on Amwell Road?
Yes, sir.
Okay. And when you bought the house, you had the house, and there's also a garage on the property?
Yes, sir.
Okay, and how many cars fit in that garage?
It's a two-car garage, but we use one car and the other side is for storage.
Okay. And how many cars do you own?
3.
Okay.
Well, 2 and 1 for my wife.
Okay. One is your work vehicle and one's your personal vehicle?
Yes.
Okay. Now, when you bought the house, there was a driveway, correct?
Yes.
Okay. And the driveway took you straight into the property to the garage, correct?
Yes.
And if you wanted to exit the property and leave your site, how would you leave your site?
Well, you have to back straight onto Anwar Road, back out.
And can you describe how backing out onto Amwell Road at that, in the morning at rush hour and the afternoon at rush hour is?
It will be a pain.
Okay.
Because cars are coming pretty decent speed.
Okay. And so when you bought the house and you realized you have a problem getting in and out of your driveway, what did you do?
Basically, put pavement around the back of the house, so we're able to make a K-turn and come out forward onto Anwar Road.
Okay. And did you get any permits to put the blacktop down?
No,
Did you know you needed a permit?
no,
Okay, so you bought the house, you said, I can't get in and out of my property, so I better blacktop this so I can get in and out of my property, correct?
yes,
Okay, and after you put this blacktop down, did you find out you did a couple of things wrong?
yes,
Okay, one of the things that you did wrong was you exceeded the impervious coverage that is allowed on your lot, correct?
yes,
Okay, the other thing that you did wrong was in putting the blacktop down, you actually encroached on your neighbor's property, correct?
yes,
Okay. Now we are here to basically cut back some of that blacktop, but allow the driveway to be blacktop so you can still safely exit and enter the site, correct?
yes,
Okay, and then Mr. Fisk has examined and analyzed what we need to do to remove some of the blacktop to keep us under a 10% increase in impervious, 1,000 square feet increase in impervious coverage. Is that correct?
yes, sir.
And in reviewing everything with Mr. Fisk, should the board grant the variance, you would remove all of the blacktop that you put in that is not necessary, and also all of the blacktop that is not on your property.
Yes,
Okay, and obviously the blacktop that you are removing, you would then replace it with topsoil and seed those areas?
yes.
Okay, thank you. No further questions.
Is there a way to mitigate some of that impervious coverage?
You can by doing stormwater management. If you keep it under a certain percentage, you're allowed to put it in without stormwater management. If you go too high, then,
No, I understand. I'm just wondering if, notwithstanding, I know, for example, one of the suggestions was the use of pervious asphalt, which I don't know whether that, in fact, is considered impervious or pervious.
It's still considered impervious.
pervious, and it may have been a good thought, but it's already been paved. So you're not going to remove pavement to put impervious. But I think Mr. Fisk can explain what's there, what we're doing, and what was there before to put this in a better perspective.
Okay.
Any other questions?
Just with, it's a county road, do you have to have any Somerset County review?
We've submitted to Somerset County. I haven't heard back from them, but the driveway doesn't change, the curb cut doesn't change. So in my opinion, they're not going to have an issue with this. The DRCC has already reviewed it, and they have no issue with this.
There's no diminishment of safety? No, it's probably better.
It's better, yeah, they should be happy that what we're proposing.
If you look on page 2 of the TRC report, I think that gives a good illustration of the before, what the applicant did, and then what they're proposing to do. Kind of the before, after, and the after the after. But it does show, though, that where it meets the street, the curb cut, as Mr. Lanford just said, the curb cut was not increased or changed.
Okay, anything else?
I got a couple questions. Did you put the blacktop in yourself, or did you have a contractor?
No,
do it?
I had a
Get
contractor.
a contractor do it. Did he ask you if you had permits?
No,
Okay. Whenever there's blacktop being done, there's always a permit needed, correct?
If you're going to increase your impervious coverage, so if that's going to be increasing your driveway, you're going to be putting a patio in,
So
a building addition, you need
wouldn't-
a zoning permit.
Wouldn't the contractor have to have that in order to put that in?
In my experience, well, yeah, they would have, and in my experience, contractors vary widely in their knowledge of local zoning codes. Some are very experienced, they know all of the different ins and outs, and some don't. Seems like this one did not.
Anything else? Again, we'll open once.
Oh, just one other question, too. We actually presented this to the Historic Commission, did we not?
Yes.
And they conceptually agreed and were approved with the removal of the blacktop to
Yes.
allow the blacktop, since this is in a historic district.
Yes.
Thank you. Mr. Fisk?
I just have one question. So the proposed, is that just removing that from the nearby property, or?
I'll let Mr. Fisk explain it, because we're actually removing stuff from our property also.
Okay.
You swear the testimony you're about to give should be the truth?
I do.
Name and address, please.
Stephen with a PH, M. Fisk, F-I-S-K, 631 Union Avenue, Middlesex, New Jersey. I'm a licensed professional land surveyor and professional planner in the state of New Jersey, and have testified before this board dozens of times.
And you're still licensed?
I am.
Okay. Mr. Fisk, and I think the best way to take this, because Mr. Healy has done an admirable job of giving the board all the relevant information concerning this application, can you take the board to what was the original condition of this property in 2017, what Mr. Barber did in trying to improve his property, and what we are proposing to seek approval for, and then justify why we are doing it?
Okay. I'm going to be stating some numbers and percentages, but they're all relative. The problem with this application and property is that it's 1/4 the size of the minimum size property in the R40 zone. And when we apply a 20% impervious limitation onto the size of the property, it becomes virtually impossible to exit this property with a turnaround whatsoever. You can't even have more than half a driveway before you exceed the allowable minimum impervious coverage. So, based on that, when Mr. Barber bought this property, there was approximately 3,098 square feet of coverage, which is 27.79%, already far exceeding the allowable coverage for this size lot. He then added some blacktop to his property line on the left as you're looking at these pictures, and behind his house, including the up to the walkway between the garage and the house, and also paved some on his neighbor's property to a curb line of their driveway. The plan is to remove all of the blacktop on the neighbor's property and some of the blacktop along the common property line on the left between Mr. Barber and his neighbor. There's a curbed island as you enter the property separating Mr. Barber's property from his neighbor, and we would have a line from that curbed island up to the garage and a small grass area between that and the property line. We would leave the rest of the pavement as it presently is. With the 3 cars on the property, it's all really necessary, to answer Mr. Healy's question, in order to facilitate a K-turn and get a car turned around while there are 2 or 3 cars on the property. The main problem on this property is safety. It's imperative that cars do not back out onto Amwell Road. I've been on the property. It's on a curve. People are going 40 miles an hour. It's also where 2 lanes merge into 1 lane. It's a hazardous area. And I would be very reluctant to even try to back out there during most of the day. It wasn't even rush hour when I was there, and that road's extremely busy. So our job here is to try to find a reasonable solution, not granting any more of a variance than is necessary, but it's really imperative to allow him to be able to turn around on this property and pull out forward onto Amwell Road. That being said, the additional impervious pavement is going to be less than 1,000 square feet from when he bought the property in 2017. It'll be considerably less than what's there right now. But it's all, in my opinion, necessary in order to park the cars on the property and turn a car around to pull out forward onto Amwell Road. As the benefits are obvious from a safety factor. The detriments of granting this variance are minimal to none. He's really not going to affect anyone else with what he's paving behind the house, which is the only real difference between the original plan and what he's proposing.
Okay. One quick question, Mr. Fisk. What percent, because Mr. Keneally needs to prepare a resolution, and so what is the proposed impervious coverage that we would have at the end of the day once we take out the pavement that we are proposing to take out?
The proposed impervious coverage would be 4,076 square feet, which is 36.57%. If you relate that to a minimum 40,000 square foot lot, it comes out 10.2%. And if Mr. Barber owned a 40,000 square foot lot, he would be entitled to 20%. So he's not really paving that much. It just seems like it because the lot's so small.
Okay. Thank you. I have no further questions.
I think, I'll say right up front, I think something needs to be done like this to protect the viability of this as a residence. Because I think we can all sit here and say, you can't back out onto Amwell Road. The other issue that goes along with that is you're actually, in my mind, creating a public benefit because the person who hits him when he drives or his family members is also affected driving by. I don't know how it ended up getting the way it is, but I don't think it's a very safe situation. Sounds like you have a plan that can fix it. That's just my opinion.
Yeah, you're absolutely correct. It's a public benefit also.
You had me at the point where you said the lot was so undersized. That explained everything. So I would agree with the chairman. It absolutely seems like a very necessary change.
Any other questions or comments? You're done, right? So
Yeah,
we're open to the public? Anybody want to ask a question?
I think
Up
I'm done.
Or make a statement. Come up to the mic. We need your name, address, and we will get you sworn in. You can use the podium.
Right to lick.
Hi, my name's Amy Thorkelson, Thorkilsen, and I am the neighbor at 1747 Amwell Road.
And could you raise your right hand? I need to swear you in. Do you swear the testimony you're about to give should be the truth?
I do.
Thank you.
I just wanted to say I have owned my house for a long time, and the two driveways always were just two straight driveways as described with an island in between them. My driveway was always paved with an impervious substance, and theirs had the previous owners had a little bit of pavement out near the street, and then the rest of it was like dirt and loose stone. They had two, sometimes three cars, and what we always did is, I don't know apron, but out at the Amwell Road, where the two driveways are together, there's a storm drain, which is drainage. But what we always did was we never backed into Amwell Road. We backed into each other's driveways, executing a turn, and always went out forward. I never had a problem with that, and neither did they, and so we always shoveled that storm drain to make sure that everything properly drained. It was a shock to come home one day and find out that I had brand new asphalt on my property. So I am pleased to see in the drawings that you will be removing that. I had contacted an attorney at the time, and he said, well, it's really your township, and I was out of work at the time and didn't have the means to pursue it. And he said, well, it's really up to your township and the zoning board and all that. And so here we are. It took us a while to get here, but it's just very important to me because I can't sell my house or do anything until that's remedied because there'd be an issue. So I'm interested to hear what the time frame might be on that and, maybe some more specifics.
Yeah, obviously, we can't do it during the winter, but it is our goal to, in the springtime, and if the board were to approve this, if they wanted to put a condition in that we would remove the excess pavement within 120 days of the resolution, I think that probably would work well. Because, again, you can't do it in the wintertime, but we will do it in the spring.
Yeah, you can only imagine if you drove into your own driveway and discovered that you had.
I get it, and I was on the property on more than one occasion, and I know what's there, and, obviously he didn't realize, but we're here to fix it.
Right. So you're moving it, but I have the previous owners, I actually have her old surveys too, and so that the line goes up to the garage.
Mr. Fisk has surveyed the property, and actually, I assume that when we're going to go out and rip whatever asphalt out, we will make sure that it is all ripped out as per the plan, because it has to be.
So what the applicant is showing is that all of the pavement that's on your property would come up, and then on their property, there would be, I guess, grass or an island of varying width, but of a few feet. So the pavement would be a few feet in off of the property line. But again, everything off of your property line would be removed.
Back to the way it was.
Yes.
I can't tell you if it was back the way it was. Looks like it's slightly, on their property, looks like there's a little bit more pavement.
But on your property, we're taking all the blacktop off and replacing it. We're going to topsoil and seed.
Right. Yeah, it's, I understand they have a lot more cars. There's always like 4 cars there, but to turn around, it is a large expanse, the master bedroom, mine, out, and it's just sort of a pavement, but anyway.
Was the time frame that they suggested, the 120-day time frame, is that problematic for you?
I've lived with it this long. I do understand that it's winter and, well, the weather's only gonna get worse, so, you can't plant grass and you can't do all that stuff right now. So I just want it to be rectified.
All right, thank you.
Amy?
Who's the inlet? Is that a county inlet?
I would believe, it was there. It's a really massive, call it like a cast iron storm drain, it's probably.
Yeah.
It's an inlet in the county right-of-way near the edge of the pavement.
And they maintain it?
Yeah, it's a county inlet.
It luckily gets sun, so as long as you shovel, you can make sure that, I always, the house was vacant, the barber's house was vacant for many years. And I always tried to make sure that I shoveled. I also needed the space to back up and, exit.
So, Amy, I take it that you don't have a turnaround in your driveway either,
No,
then?
mine's straight. I just,
have to
like I
back out.
said, I pull in and I circle into their driveway and I always go out forwards. And I would always tell people like PSE&G or whoever came, I'm like, please don't back out. Just put your butt into the driveway and go. Because the apron's really large, the apron, whatever you want to call it, the common area where the storm drain is right at the tip of the island, and then there's an open area where both of our driveways, where the cut goes, and then the common.
The photo on page 3 shows what she's talking about.
Yeah, I think there's a Google photo that you got. Yes, you can see the storm drain. Anyway, that's.
Thank you.
Back to sign.
Thank you.
Thank you. Anybody else? Okay, then we'll close to the public and sum up.
I'm not going to sum up. I think the statements made by Ms. Grauman and yourself as to the necessity of this is apparent, and I would respectfully request that the impervious coverage variance be granted.
Okay, any comments, questions, or motion?
Move that this application be granted and that work be done, at least commenced within 120
I think they said
days.
120 days. So what I would suggest, if I could suggest a slight, that they do have to get a zoning permit for the expanded driveway, that they have to do that within 30 days and do the work within 120.
Sounds good to me.
Anything else? And we need a second?
I'll
I'll
second.
second.
Laura Grauman,
Yes?
Bruce McCracken.
Yes.
Alan Rich.
Yes.
Gary Rosenthal,
Yes.
Cheryl Bethia,
Yes.
and Chairman Thomas.
Yes, okay, I hope we get this right for everybody. Okay. Rental House, LLC, ZBA 19-00032, pre-existing non-conforming use which the applicant contends that the property is a two-family dwelling and was so prior to adoption of the first zoning ordinance, 17 Home Street, Somerset, Block 184, lots 16 to 18 in the R7 zone.
I think I've got one more left in me. Good evening, Mr. Chairman, members of the board. Peter Lanford appearing on behalf of the applicant. This application, as you indicated, is certification of pre-existing non-conforming use. I intend to call two witnesses this evening, the owner of the property, Mr. Calarackle, and also David Beekes, who made an examination of the property and will render testimony as to the age of the property and also the fact that it was a two-family house. I will call Justin as my first witness.
Do you swear the testimony you're about to give should be the truth?
I do.
Your name and address, please.
Justin Calaragal, 1818 Oak Road, North Brunswick, New Jersey.
Could you spell your last name, please?
Kallarackkal.
Thank you.
Be seated, Justin. Justin, you're the owner of the property?
Yes.
Okay, and when did you acquire the property?
December 2018.
Okay, and how did you acquire the property?
It was a foreclosure.
Okay, and you bought it from a bank?
Yes.
Okay, and when you bought the property, was it occupied or was it empty?
Empty.
Okay, and on the property is located a building, correct?
Yes.
Okay, and when you went to the property, did you go through the property before you bought it, or did you go through the property and examine the property after you bought it?
After I bought it.
Okay. When you bought it, did the information that you received when the property was up for sale indicate whether it was a one or two-family house?
Two-family house.
Okay. And you bought it because it was a two-family house, is that correct?
That's right.
And it was your intention after you, all right, let me back up. When you went through the house, what kind of shape was the house in?
It needed lot of work.
Okay. And,
Sorry, it needed
Needed a lot of work.
a lot of work,
Yeah.
okay.
okay. And then did you apply for permits, unlike previous applications, in order to do the work to upgrade the house?
I did.
Okay. And did you start to do some of the demolition inside the house?
Yes, I did.
Okay, and when you applied for the permits, did the building department say that there was an issue with the property?
Yes.
And what did they indicate to you?
They indicated that it was a one family in the records.
In the township records, it was a one-family house?
That's right.
Okay. When you first went into the house and observed it after you bought it, is this a one-story or two-story house?
Two-story.
Okay. And on the first floor of the house, how many rooms are there?
One bedroom, living room and kitchen,
Okay,
bathroom.
and a bathroom. And where is the entrance to the house, to the first floor unit?
17 homes, Home Street.
On Home Street. And on the second story, what did you find when you went through the house?
One bedroom, living room, kitchen, one bathroom.
Same as the first floor?
That's right.
Okay. And was there a separate entrance to the second floor?
Yes, through the back of the property, it's a stairwell.
An exterior stairwell up to the second floor, correct?
That's right.
And there was no connection between the first floor and second floor at any time?
No.
That you saw? Okay. And then when the township says that you only had a one-family house, or the records indicate it was only a one-family house, they basically said you can't do any more work until you get it certified as a two-family house. Is that correct?
That's right.
And so you stopped doing all the work, and we're here tonight to get it certified. Is that correct?
That's correct.
And your ultimate goal is to rehab it and to turn it into or to continue to use it as two apartments?
That's correct.
Thank you. I have no further questions.
Anything from the board?
I just have one question. So you said you did not look at it before you purchased it?
It's a foreclosure, and there's no access.
Okay.
So, Mr. Lanford, you may have addressed this, but this property is in the R7 zone.
That is correct.
So this is similar to that first application where it's two-family homes are a permitted use in the R7 zone. So it's not a use issue, but you have 7,500 square feet and 75 feet of frontage where you're required to have 15,000 square feet and 150 feet of frontage. So it's really, the deficiency is the lot area and the lot frontage.
Yes and no. It's our position that there is no deficiency because there's a pre-existing non-conforming use. If this was a vacant lot and we were trying to build a two-family house, we couldn't because we did not have enough area or frontage. But it's our position that it was always a two-family house on a 7,500 square foot lot as a pre-existing non-conforming use.
Okay, I agree with that. What I'm pointing out is this is not a two-family home in a zone that only permits one-family homes.
That is correct.
Okay, thank you.
Any others? Okay, we'll open after, and we'll
Mr. Beekes.
You swear the testimony you're about to give should be the truth?
Yes, I do.
Your name and address, please.
David Beekes, 45 Hunt Lane, Skillman, New Jersey.
Could you spell your last name, please?
Bekus.
Mr. Beekes, what is your occupation?
I'm a licensed building inspector. I also am a builder and a renovator of homes.
Okay. And have you appeared before boards and testified before boards as far as your examination of homes to determine their age and their use?
Yes, including this board.
Okay, and you were qualified before this board and testified before this board previously?
That's correct.
Okay. Now, the property that we're talking about, you've had an opportunity to observe the property?
Yes, I visited in July
Of this year?
of this year.
Okay, and at the time you visited it, had some of the demolition that Justin testified to already taken place?
Yes, the interior was not completed, but it was the existing stuff was removed.
Okay, and first of all, when you examined the interior of the house, you heard Justin testify that it was basically two apartments, one on each level. Is that also your conclusion as to what is currently there on the property?
Oh, yes, definitely.
Okay, and again, they had separate entrances to each of those
Yeah,
apartments?
the first floor is entered from the front, the second floor is entered from their back. They're completely separate. Everything that I saw there indicated those were there for quite a long time.
Okay, now, we get to the quite a long time issue. Can you indicate to the board how you determined or made a determination that this house was a two-family and for how long it had been a two-family and that it predates the zoning, which is 1959.
Typically, we look at the interior of the two homes or the two areas. In this case, because it was demoed, I couldn't look at kitchen sinks. I couldn't look at furniture or anything else that was in there because it was removed. However, the rear stairwell, everything about that indicated construction almost immediately after the first house was built, which was listed as a single family. Interestingly, the only thing that is different from the construction of the first, for the front part of the house and the stairwell, is the siding. If you look at the framing in the basement below the addition, it's the full size. It's like 2¼ inch. It's not anything modern. That was used, you know, the 30s and the 40s. It wasn't until the early 60s that, you know, dimensional lumber that we're common with now started to be used. If you looked at the locks, the mortise locks, they got done being used in the 50s for the most part. They were definitely predates. Everything in this addition or in this stairwell in the back is almost identical to everything in the front of what was left. The framing, the siding, not the siding, the framing, the sheathing on the inside, the locks, the stairs. There was, you know, the hinges on the doors, again, matched everything on the existing home or the first part of the house. The foundation was a rubble foundation. You know, in other words, built out of stones, not in any kind of block or brick or anything like that. That indicates, you know, very early construction. So in my opinion, this was here, even possibly at the original construction. It was an afterthought shortly thereafter the house was originally built. In addition, I'll add another thing. Because the house was demoed, there was no indication of a prior staircase at all in between the two floors. Normally, once the house is demoed, you could tell that there was stairs there at some point. There was no indication in this house that there were stairs connecting the first, other than the stairwell in the back of the house. There was no interior stairs communicating between the two floors.
So based on all of the things that you examined and all of the things you reviewed, the second floor had access through the rear and existed as a separate apartment from the first floor prior to 1959.
I would say definitely prior to 1959, and if it was probably shortly after the house was built that it was
Okay,
done.
and do you know when the tax records indicate approximately when this house was built?
1920.
Okay, thank you. No further questions.
So let me summarize if I could. So the original house was the brick part.
That's correct.
And then what you're saying is that the addition, which is on page 4 of your report, has the yellow siding.
Aluminum
That
siding,
addition
yeah.
was put in as stairs to provide access to the second floor?
Yes.
And that addition has the locks, the hinges,
Yes.
the rubble foundation. So the addition that provides that access between the two units, that predates the 1958?
Yes.
Okay.
Everything that I'm discussing about when it was built is that addition, not the existing house. What I'm saying is the addition, the construction actually, except for the siding, except for the brick, it matches everything in the primary structure.
Oh, okay. All right, thank you.
Any other questions? Any other witnesses?
No other witnesses.
Open to the public. Is there anyone who wishes to ask a question or make a statement? We'll close. You.
I will rest to not proffer a closing statement.
Anything from the board, including,
Very convincing.
including a motion?
I move that,
Pictures were great.
yeah, the whole report was really very good. I move that the application for certification of pre-existing non-conforming use be approved.
I second.
Laura Grauman, Bruce McCracken.
Yes.
Alan Rich.
Yes.
Gary Rosenthal.
Yes.
Cheryl Bethia.
Yes.
Chairman Thomas.
Yes.
Thank you very much. Have a good holiday, everybody.
Thank you.
Okay, Madalena, you too. Rubino, ZBA 19-0003 8-9, applicant seeking a C variance to construct a roughly 8 by 5 feet, 40 square foot, one-story porch to the front of a single-family home, 557 Garfield Avenue, Somerset, Block 555, Lot 11, in the R10 zone.
Good evening. Are you both going to be testifying tonight? Yes. Okay, could you each grab a microphone in your left hand and raise your right hand? Do you swear the testimony you're about to give should be the truth?
Yes, I do.
Speaking right into the microphone, one at a time, give us your name and address, and have a seat.
Dan Fortunato. I am a registered architect in New Jersey.
Spell your last name, please.
Fortunato.
Thank you.
Madalena Rubino, 557 Garfield Ave, Somerset, New Jersey.
Thank you.
Okay. We are here tonight because I am the architect that designed the interior renovation for the property on 557 Garfield Avenue. During the design process, there is a setback requirement of 25 feet. The current house has a front porch on it, which was sort of half renovated to make it sort of semi-habitable from the previous owner, which sits 21 feet approximately to the front setback. What we are here today for is to improve the quality of the home for safety and aesthetics by adding a front porch on the front elevation. Currently, there is no entrance to the front of the house. There's 2 sets of windows. The only way to get into the house is on a side entrance of this porch that already encroaches the 21 feet.
That's what I was wondering, when I looked at this picture, is this picture with the red awnings, that's the front elevation?
That's the front elevation of the house, that's correct. So to get into that location, you have to do a 2 concrete step up from the driveway directly into a side door on that, which is dangerous because if you look at the site plan, you'll see that the driveway is right up against the house. So anyone stepping out of the house steps right into the driveway. So the proposal is to add the front porch structure because based on today's IRC codes, you need to have a landing in front of a door. We cannot get a landing in front of that side door because you're already into the driveway. So the 5 by 8 proposed structure is going to provide a new front entrance, make it a little nicer looking for the house, as well as get it away from the driveway so they can enter the home.
But you have elevations that show the look afterwards, right? You have a front elevation that shows, and then you have the side elevation that shows that it's not an enclosed porch. It's you have pillars and it's a kind of like a roofed open porch, correct?
The existing structure is enclosed.
I'm talking about the proposal.
Proposal open, just calling it is.
Okay, and that shows on the front elevation would show the look of the house from the front, and the side elevation shows that it's a open roofed porch supported by columns.
That's correct. It's not part of the habitable area. It's just front porch.
Almost at a loss for words. Is there anybody who needs any other information for this? I'm assuming, I'm going to say that this is the front of the house, that's the address. The street we see is what its mailing address is. There's no, obviously, door there. 40 square feet, you have a hard time convincing me is a problem in any way for impervious coverage.
No.
What else do we need to move this, if any?
Well, you do have to open to the public. I mean, I'll say quickly, I think this could be supported both as C1 and a C2. It's C1, it's I think it's an older house that's already placed closer to the road, and that any improvement in that area would result in a variance. I think you could also make a C2 argument that it improves the usability of the property and also improves the aesthetics.
How long have you owned this house?
It's August.
I can't hear you.
Use the microphone, please.
August 2019.
Are you, it's irrelevant, but just curious, did you buy this to own or to rent?
To own.
I mean, for your own?
To live in, yes.
Yeah.
Yes.
I think the architect also mentioned the safety aspect as well.
Well, it also looks like a house that's not finished. If you can't get in or out of the front, that's pretty unusual compared to what we usually see. Any other questions or comments? Open to the public. Anyone have a question or a comment? Nobody, good. I don't even think you need to summarize. Could we have a,
I move it.
Second.
Second.
Laura Grauman, Bruce McCracken.
Yes.
Alan Rich.
Yes.
Gary Rosenthal.
Yes.
Cheryl Bethia.
Yes.
And Chairman Thomas.
yes, and good luck with it.
Thank you very much. Have a
And
happy
if
holidays.
there is no other business, we'll entertain a motion to
So
adjourn.
moved.
Second.
Right. We'll say happy holidays to everybody and happy new year, and we'll see you after the beginning of the year, and the meeting is adjourned.